All right, as Omar just explained, he is just 10 miles from where Derek Chauvin's murder trial is set to get underway. Prosecutors are expected to rest their case today, Anne-Marie, and yesterday, as you know, jurors got another look at that harrowing video of George Floyd's final moments and heard from a use of force expert who said officers mishandled the arrest on nearly every level. Witness testimony turned emotional, though, when Floyd's brother took the stand to share tender memories of the 46-year-old. Jamie Yukas is in Minneapolis with more.
After more than 2 weeks, the prosecution is expected to rest its case today. Yesterday, prosecutors focused on appealing to the jury's emotions and put George Floyd's younger brother on the stand.
He just knew how to make people feel better.
Heartbreaking testimony from George Floyd's younger brother, Philonis.
He showed us how to treat our mom and how to respect our mom. He loved her so dearly. I miss both of them.
Jurors listened as he described growing up with his big brother and the joy he brought their family.
He was so much of a leader to us. He used to make the best banana mayonnaise sandwiches, and he used to make syrup sandwiches because George couldn't cook.
CBS News legal analyst Ricky Kleeman says the younger Floyd was used as what's called a spark of life witness, meant to show the jury just how much George Floyd's life impacted others.
I think George Floyd's brother influenced the jury in all kinds of ways. This is obviously very, very painful for him and for his family. And jurors are people. They can feel that kind of pain.
Earlier on the stand, cardiologist Jonathan Rich echoed previous testimony and said George Floyd's heart stopped because of low oxygen levels caused by ex-officer Derek Chauvin's actions. Before the trial resumed Monday, the defense asked to sequester the jury because of the fatal police shooting of Daunte Wright.
I think brings it to the forefront of the jury's mindset that a verdict in this case is going to have consequences.
But the judge denied the motion, a move Ricky Kleeman disagrees with.
They can't get away from it when they go to the courthouse, and they can't get away from it when they go home. It seems the only reasonable thing to do would have been to have sequestered them on Monday.
The defense is expected to begin its part of the case today. It's not clear how many people it'll call to testify or if Chauvin himself will take the stand. The judge told the jury it should expect closing arguments next Monday, and jurors will be sequestered once deliberations begin. Vlad and Anne-Marie.
All right, Jamie, thank you very much. For a legal perspective, let's bring in CBS News legal contributor Jessica Levinson. She's also a Loyola Law School professor. So, Jessica, we are hearing that Derek Chauvin may take the stand today. How significant would it be for the jurors to hear his testimony at the top of the defense's presentation? I know that as a law professor, you probably advise students that when they become lawyers, they'll have to make this decision. Would you advise that it is a better strategy for the defense to present Mr. Chauvin at the top of their case, their defense, or at the end?
Well, of course, I'm going to give you everybody's least favorite answer from a law professor, which is it depends. I mean, it depends on the case. In this particular circumstance, I think that the defense realizes that the prosecution has put on a very strong case, and they want to come out with a big, quote unquote, emotional wow moment. They don't want to just kind of back into the idea that Officer Chauvin, in fact, used reasonable force, that he wasn't the substantial cause, that there's at least a little bit of doubt. So it's an interesting strategical decision that they don't want to start with, for instance, other medical experts, that they don't want to start with other use of force experts, that they want to go straight to hearing from Officer Chauvin, if in fact that is what they ultimately decide to do. We've talked about this before. It opens him up to a lot of cross-examination questions about, haven't you been the subject of complaints before? You're a veteran of the force. Don't you know what excessive force is? You just heard all these experts say no reasonable person. How do you respond to that? I think that, again, the defense is just trying to find that one juror who maybe can look at Officer Chauvin and say, you know what, that does seem like it was an ever-changing situation. Maybe we can't tell from the video exactly what his perspective was, although, frankly, I think we can. But, yeah, they want to come out with a bang, not end with a bang.
So the prosecution's final witness yesterday was a use of force expert. His name was Seth Stoughton, I think. He testified that officers severely mishandled the arrest of George Floyd almost on every single level. I want to play some of what he had to say.
There's no specific and articulable facts that an officer, a reasonable officer in the defendant's position could use to conclude that he had the intention of causing physical harm to the officers or others.
Would a reasonable officer on the scene then, hearing this, have at least been aware of the complaint?
Absolutely, especially when you hear an officer respond to that complaint. It's certainly an indication that an officer was aware of it.
So we've heard the phrase reasonable force, but not so much reasonable officer. The word reasonable, what's it in reference to? How is it defined in this context, and why is it important?
Well, it's important because it helps us inform our inquiry as to whether or not Officer Chauvin acted appropriately. Reasonable is a word that we use so many different places in the law. We see it in civil law, we see it in criminal law. What we're trying to talk about not is just what did Officer Chauvin do? Was that appropriate? But how he acted as a person. Would any officer with his training have decided that that was a reasonable amount of force? So it's both the person and the action that they're trying to get at. And frankly, I thought a use of force expert, who's not only one of the nation's experts, but a former police officer, saying over and over again, no reasonable person, that again personalizes it for the juror. It humanizes it. It means that it's not just this abstract legal concept. You know, who I talk to my students about, who's the reasonably prudent person. Well, it depends on the community. It depends on all these standards. Saying no reasonable officer gives them a context for making that decision, for engaging in that analysis.
Jessica, the defense filed a motion objecting to Stoughton's appearance on the stand, but Judge Cahill allowed the use of force expert to testify. However, the judge did say that he was concerned by the number of use of force witnesses the prosecution is calling. First question is, I guess, why might a judge have those concerns over the number of witnesses testifying on a particular topic? We've talked about that before, that after a certain period of time, it would strike me as a layperson that the jurors and somebody who's watching the trial, like I am, would say, I get it. I understand what the prosecution's case is and what they are suggesting Derek Chauvin is guilty of. What do you think?
So that's right. I mean, what the defense said here is basically, we get it, and the prosecution is over-trying its case. It's over-trying its case so much that it's actually excessive in this case. And the judge said, okay, basically one more. We get the point here. And why is the prosecution doing this? Because they're worried that the jurors will not like one of the experts. I think that's what's going on here in part, is that they're worried that just on a human level, the jurors are saying, I didn't really trust that person. I don't really like that person. Maybe I can't really put my finger on it, but I don't want this whole case to hinge on that person. So they basically give the jurors a menu of choices of experts who are saying very similar things. Frankly, we've had that with respect to medical experts as well, where we've had medical experts say the same thing a number of different ways. Now, it's not bad for the jury to hear some repetition. I think it's helpful for the prosecution's case, but you do want to be careful that you don't turn off the jury. And there is a certain point where, again, you're over-trying the case, it becomes excessive, and it's no longer in the jury's interest, and you're basically wasting their most precious resource, which is their time.
So prosecutors also brought in what's called a spark of life witness yesterday. It was George Floyd's little brother. Normally, a witness like that would be reserved for, you know, a victim impact statement, maybe after the arguments have already been heard during the sentencing process. But things are a little bit different in this state, so you can have this spark of life witness. Why did the prosecution choose to do this? And what about the defense? Is this a difficult witness for the defense to kind of cross-examine?
Yes, a very sympathetic witness. You have to be extremely careful about cross-examining the victim's family, not just because you want to be a decent human being, but because you don't want to appear like an indecent human being in front of the jury. And we have family members here. We had two spark of life witnesses. We had George Floyd's girlfriend, who I think in many ways humanized his drug use. Yes, we struggled with addiction. A lot of people struggle with addiction. We're not just figures. We're not just statistics. We're still numbers. We're still people, excuse me. The same thing with respect to George Floyd's brother, really saying, please don't just view my brother as some other number, some other person you would read about in a newspaper and say, oh, that's tragic, kind of turn the page. Please see my brother as the person I used to play video games with, who made me sandwiches, who loved his mother so much. It is, as you said, it's unusual. Minnesota is unusual in the sense that they allow these character witnesses in the guilt phase, because whether or not George Floyd was a wonderful person and loved his family doesn't actually legally have anything to do with whether or not Officer Chauvin engaged in activities that would lead to either second or third degree murder or second degree manslaughter. But it's to allow the jury to hear from George Floyd essentially beyond the grave, to make him a fuller human for all of the jurors.
Jessica, real quick, in 30 seconds before we go, could this quote-unquote overkill of the prosecution witnesses mean at some point, first of all, could Mr. Chauvin's attorney object to the number of prosecution witnesses and say, like, this is overkill? And could that lead to problems later on? Let's say there's a conviction and somebody looks back at this and says, Derek Chauvin's attorney probably should have tried to limit the number of witnesses the prosecution was calling.
Yes. I mean, so your question about what could you take up on appeal, absolutely both sides are already taking notes on what could you potentially take up on appeal. The idea that there were too many witnesses, I don't think that we're there. That would not be, like, you could take it up, but I don't think it would be a particularly successful argument. I think that they just kind of pulled back from that moment when they were about to start overtrying. That's where I would see closing, and I think I'm well over 30 seconds.
Got it. All right, Jessica Levinson, always great to talk to you. Thank you very much.
Thank you.